Welcome to Swala Nyeti, the law podcast that pairs a layman and a lawyer to answer your legal questions of the day. Swala Nyeti is sponsored by the law firm of Kajiado and Company Advocates and is intended for educational purposes only.
Welcome to Swala Nyeti. This is the layman Kashao Patrick, and this week, as promised last week, we go on with the series of the layman versus many lawyers. This Monday morning, I am joined by Mbuthia Mwangi and will be handling Mashamba Monday. Mbuthia Mwangi, welcome to Swala Nyeti. To start us off, Wakili, my neighbor is encroaching on my land, claiming that I grabbed it from him and now threatening violence. What can I do?
So the first thing he can do is go to the police and institute a case against the neighbor for threatening violence. Secondly, and after reporting, he will get an OB number, which he will use to pursue the case. He can then use this and institute a suit under the Environment and Land Court, and he should ask for interim injunctive orders, also known as conservatory orders, which will allow an order of the court for status quo to remain, which is the boundaries as they are to remain and not as claims that the other one grabbed from the other one. And then now the court will listen to the suit to finality and give final orders as to the proper boundaries. It might require the land to be resurveyed to solve the issue conclusively.
Question number 2. The bank is asking for spousal consent to charge land in my name, but I am polygamous. What do I do?
So the best thing for him to do is to convince all the wives to execute the spousal consent, which is in form of an affidavit, whereby all the wives will confirm that indeed they are married to the individual and they are aware that he wants to charge the particular property, and either the property is not part of matrimonial property, or if it is matrimonial property, they give the consent for the bank to charge the land. Contrary to this, the individual risks a scenario where the bank will refuse to give the banking facilities, as banks would like to avoid a scenario whereby in the case of default, there will be someone else who has a superior right to the land than them. And this is for purposes of exercising the charges power of sale, whereby if you default, they'd like to have a chance to sell the land and recoup their money, and hence it will be very important for him to be able to get all his wives to execute the spousal consent.
Question number 3. I have a 5-acre plot of land in Kajiado that I want to subdivide and sell. What is the process?
The process of subdivision of land begins with the proprietor approaching a physical planner who will prepare the physical plans of the intended subdivision, and then these prepared plans will be submitted to the relevant county government, in this case Kajiado County Government, and form PPA1 for the county government to give its approval. So the county government will consider the plans, and it's important to use professionals for this process because, for example, in Kajiado, they did not accept subdivision of land, to either an eighth or a quarter. Hence, the intended subdivision should be limited to either an acre or half an acre. So, depending on the county government policy, so it would be very important to approach someone who understands all this. So, once the plans have been considered by the county government and they agree with them, they will issue an approval and form PPA2, and with this approval, the proprietor will now be able to get a surveyor to resurvey the land with the consideration of the plans. So the surveyor will need to now prepare the land to have amenities, e.g. access roads, water drainage, in the event there are no power lines, where the power lines will pass through, or where in this modern day age where fiber cables will pass through. Once the survey has been done and a cadastral map or a mutation plan for the land has been prepared, all these documents will now be submitted back to the county government for them to issue a provisional subdivision certificate. So With this now provisional subdivision certificate, the proprietor will now be able to visit the lands office for the lands office to close the mother title, the green card, and for them to open new titles, for them to open new registers for the lands for subdivided plots and issue new titles for the subdivided plots.
Question number 4. Someone sold me land in Nakuru, but he only had a letter of allocation. How do I get the title deed?
It's important for the individual to understand that letter of allocation does not confer any interest in land, and that the law only recognizes a certificate of title or a certificate of lease as evidence of land ownership. Secondly, a transfer of ownership cannot occur in the absence of a certificate of title or a title deed, which then means that the letter of allocation in this case cannot transfer any interest in land, and it's taken to be a mere letter of offer from the one who gave it, which in most instances is the government of Kenya, to the person who was given for a particular purpose and a particular time period until now the grantor will require the land back. So for this individual, if he would like to get a title, he would require that to initiate the process of adjudication, and this he has to do with the help of the National Land Commission and the Ministry of Lands. Only after adjudication can the land, which adjudication is the process of surveying the land and creating a land reference number for the land, and only then can title be processed.
And the final question on Mashamba Monday: what is the risk of letting someone be a tenant as he also arranges for financing to buy my house?
The risk that arises is letting premises to the potential purchaser without an agreement to govern the possession granted. So I think it will be important for the proprietor of the premises to separate the two transactions and create an agreement to govern the possession even. So this would be either a lease or, depending on the time it will take, but the best type of agreement would be either a tenancy agreement where they will agree on the rent payments per month or per quarter, or a license, which will also agree on the license fees as they await to execute the sale agreement for the purchase of the premises, and maybe can have terms in the tenancy agreement or the license that the same would terminate on execution of the sale agreement, with the option of purchase price coming from a financier.
Thank you for joining us on this episode of Swala Nyeti Mashamba Monday. Please join us tomorrow on our Total Tuesday episode with Awangoi Waihura, and I look forward to having you. Have a lovely day.
You have been listening to Swala Nyeti. If you have a legal question that you want answered, send us a WhatsApp message on 0708 111 or email us at admin@swalanyeti.org. You can find downloads to all our podcast episodes on our website www.swalanyeti.org.